appeal in the matter of general medical counsel and
Yes, Mr.
Thank you, my lord. My lord, before I start, can I give you the answer that I've obtained in relation to the identity of the case examiner's question you raised?
Oh, yes, thank you.
They weren't the same. That is to say, the case examiners who did the Rule 8 decisions in relation to Mr. Karim and Mr. Laniardo. Sorry, my lord. In relation to Mr. Laniardo, the Rule 8 decision was made by two case. They're all both made by two case examiners, of course. Angela Ginnever.
I don't mind you know mentioning the names.
Oh,
but
I see. They weren't the same.
What I was trying to get at was whether they were the same.
No, they weren't the same. One of them, in Mr. Laniardo's case, was Mr. Smythe, who was the case examiner called by the GMC, and you'll see the tribunal refer to his evidence at ET 110. Sorry, 101. I apologise.
Yeah.
I have the names for the others if
No,
you like.
no, that's
It's
fine.
not necessary.
And the decisions they took, I mean, I ought to have these in my head, but for Mr. Laniardo, that would be the decision not to, well,
I was just about to take your lordship to that
Oh, okay,
decision,
yes,
actually, so
right.
I wonder if that might be an easier way of...
Just on identity, when you said they weren't the same, do you mean they were both different?
Yes.
Yes.
Yes. So there were four case examiners who made the two decisions.
Thank you.
and well, just while we're on this,
Yes.
was this explored at the hearing? I may be completely wrong, and I'm certainly not suggesting we deal with this as a matter of law, but just so I can get my background thoughts straight, the legal focus in any particular decision must be on the individuals taking them, however much you may say they may be influenced by a corporate culture or whatever it may be. And I suppose we have been told by Ms. Monaghan there was complaint that they weren't all called. So the tribunal was certainly alive to the fact that they were having to decide on the motivation, not the motive, but what was going on in the heads of four different individuals.
Well, at least. I mean,
yes, all right.
Of course, but
yes, yes.
Well,
exactly. We just looking at these decisions.
Yes, yes. Just looking at those decisions.
Yes, as you say, on delay, goodness knows how many individuals.
Right. Yes. Well, we know there are a change of investigation officers, for example, and that contributed towards
the delay. But this was a point that was raised before the tribunal.
It was raised.
Yes.
We responded to it in each of the witness statements. Had a section on which witnesses on behalf of the General Medical Council had a section which set out how many decision makers were involved.
Yes.
And then the person who was chosen to give live evidence stated that they felt, having read the file, that they were in a position to speak to those because of the point I think it was Lord Justice Underhill made yesterday. The decisions made are detailed, written decisions made contemporaneously and stored on the General Medical Council's document control system.
Well, thank you. As I say, that's not directly relevant to any of the issues. I want to make that clear, but inevitably when one's thinking about a case, one just wants to see what the real issues were. Yeah, thank you.
There was also, sorry, just for the completeness, my lord, in our closing submissions before the Employment Tribunal, at the time that this case was argued, we had the benefit, if I can put it that way, of the Court of Appeal decision in Aphobi, which, as you may remember, has a passage saying tribunals, where there are multiple decision makers within an organisation, tribunals should be slow to draw inferences from the fact that they're not all called. Now, when that went to the Supreme Court, and I put it Aphobi, unfortunately that paragraph didn't make it through. And Lord Leggett says it all depends on the circumstances as to whether or not you draw an inference, which is obviously right. But to address your Lordship's question directly, it was a matter that was addressed in front of the tribunal.
Well, thank you. I won't detain you any longer. You were going for another reason.
Well, I was just going to give you the references, if I may, to the MPT decisions made by these four case examiners. Yes. In relation to Mr. Karim, That's in the GMC's unagreed bundle, or GMC's supplementary bundle, pages 56 to 71. I will be going there later. And in relation to Mr. Laniardo, sorry, it's 120 to 124 in the same bundle.
What was? Sorry, I was being a bit slow. What were the references?
Yes.
One.
So for
Karim,
Mr. Laniardo, it's 120 to 124 in the GMC's unagreed bundle.
Yeah.
And in relation to Mr. Karim, in the same bundle, 56 to 71.
Mr. Hare, the rules you showed us yesterday said that the case examiners operate in pairs, and they're expected to agree, and there's quite elaborate provision for what happens if they don't. You don't have to be worried with that. But looking at, for example, the first decision by a case examiner in relation to Mr. Karim, reference to the interim orders panel, that's at pages 22 to 31. It's not, as it were, signed by a named individual, but it's all written in the singular.
Yes. Referrals to the IOP. I'm sorry, that's not under Rule 8.
Okay.
Referrals to the IOP is a single case examiner.
That's the assistant registrar.
No.
Oh.
No. It's referred to the case.
I thought you told us yesterday, like my lady, I made a note that those decisions were made by the assistant registrar,
Well,
or have we both
that's why-
misremembered?
I'm sorry, that's why I showed them to you. So it's in the GMC's unagreed bundle. The assistant registrar's decision is at pages 19 to 21. That was the decision, if you remember, that says this is adverse, this isn't adverse.
Oh, I see. Thank
Then
you.
Sorry.
it says at the end, therefore raise an IOP decision.
I'm sorry, that was me.
I'm sorry too. Okay,
And
now
that
it comes back
follows-
to me. Yep.
And that's the case examiner
Yep.
decision at 22 to 31 that we looked at some length yesterday. Does that answer my last question?
Yes, it does. So that the referral to the, as it were, a full hearing of a fitness to practice panel as opposed to the interim orders panel, that's done by two.
Yes.
Thank you.
Thank you, Rob. But where I got to yesterday, I think, was I was making the point based on McDonald, which I showed the court, you'll recall, yesterday, that what the Employment Tribunal should have been undertaking as its reasoning process was identifying, first of all, the characteristics of Mr. Karim, which led to the decision of which complaint was made, in that case the second referral to the IOP, and then ensuring that all of those characteristics were also found in the comparator. So that's what I was saying. I don't want to take the court back through parts of the Employment Tribunal decision to which the court's already been taken, so I'll just assume that the court has in mind the matters that were discussed with my learned friend yesterday. And I was going to pick it up, if I may, briefly, before moving on, at paragraph 47 of the Employment Tribunal's decision. If I can set up what my submissions are going to be, they are essentially this, that yes, it's true that if you look through the whole of the Employment Tribunal's decision, you do see that the tribunal made reference to the differences between Mr. Karim's case and Mr. Motuala's. And almost most strikingly, in relation to this issue, which I'm just finishing up on, the second referral to the IOP, paragraph 10 of their factual summary, it's very clear. It says, the respondent's case examiner decided that the findings in the Hollywood report, that included the 3 findings said to be well-founded, including the Dr. Robinson allegation, and the further matter concerning Dr. Hayter, merited referral to the IOP. So we can't say that the tribunal were unaware of it. What the GMC is unable to understand is how, given that it was aware of those differences and the emphasis placed upon them by the General Medical Council, how it was able to conclude, consistently with McDonald, and Shaboon and all the other authorities that talk about who's an appropriate comparator, that Mr. Laniado was an appropriate comparator because of what we say are the absence of those relevant characteristics which led to Mr. Karim being referred to the second IOP. And as I said, I'd like to pick that up, if I may, at paragraph 47 of the Employment Tribunal's reasons. I'm not going to read all of these out. There are just a couple of points I wanted to highlight, if I may. The court will recall that paragraph 47 begins, there is evidence of a difference in the treatment of the claimant in contrast to Mr. L. Paragraph 47 is in the section which begins at paragraph 41, dealing with the decision to apply for a second time to the IOP in February 2015. So it's clearly talking about this issue. So they identify the difference there. They then go on to say the allegations against the claimant of Mr. L arose out of substantially the same matters and were similar allegations. In the one case, it was considered there was no realistic prospect of success. We just pause there for a moment. That, of course, is not correct at the time. At the time that Mr. Karim was referred to the second IOP in February of 2015, Mr. Laniado's case was still open. It wasn't closed until November of 2015. But in any event, in the other, Mr. Karim's, the matter was pursued, relying on, and this is the crucial passage we say, on what must have been the same evidence. Well, I took the court yesterday and won't take the court again through what the evidence was that the case examiner relied upon. Not only was it not the same in relation to the two incidents which overlapped, but there are a number of additional matters too. So that's 47. Can I take the court then? I'm skipping over the ones my learned friend has already taken you to. I hope that's sensible because I'm obviously trying to save time. If we move on then to 70 and 73, two passages that I don't think have featured much yet. And to put those passages in context, the particular of discrimination which was being addressed beginning at paragraph 68 is that which the court will find at the bottom of page 121 of the core bundle, going over onto the next page. It's quite a lengthy one. And I'm not going to read it all out, but just to give the court the gist, bringing and continuing proceedings against the claimant in respect of allegations in respect of which there was no prospect of any MPT finding that the claimant's fitness to practice was impaired generally, and in particular, and then it goes on with a number of particulars, and the second of those, in Roman numerals over the page on core bundle 122, is in respect of the complaint relating to Mr. Rao. Mr. Rao did not provide any witness statement, nor was he interviewed by the GMC. So this is what the tribunal is addressing at 73, and we see its conclusions there. Could I ask the court just to read 73, please?
Yes.
We say that's a clear finding that in relation to this particular, which included the decision to bring and refer to the MPT the Rao complaint about the canteen meeting, the conclusion of the tribunal, the central sentence, is that there was no less favourable treatment. One looks then at paragraph 95. Now 95 is part of the section in which the ET address the particular of proceeding to the MPT hearing in March 2018. The court will see that above paragraph 86, page 126 of the core bundle, in italics there, proceeding to the MPT. Yeah. Paragraph 95, you have looked at this. The tribunal did not consider there was any less favourable treatment in the claimant's case being put to the MPT. That's the finding, we say, in relation to this matter. But then, I'm not going to read that out, the bottom half of this paragraph, which my learned friend put to you,
Sorry, which one?
Sorry, paragraph 95,
95.
bottom of page 127.
Yes, I haven't marked this up as having been.
Oh, I'm sorry.
It may just be a failure on my part.
Well, perhaps I should.
No,
If
if you're sure Miss Monaghan took us to it, I just perhaps didn't mark it.
so it's that passage beginning, however,
Yeah.
in respect of the manner in which the respondent dealt with the AR allegations, there was an inconsistency in the treatment of the claimant and Mr. L. Claimant's case, AR allegations were to be left to the MPT to determine. Now, I've just showed at 73, the tribunal's just said there was no less favourable treatment in that matter proceeding to the MPT in relation to Mr. Rao. Again, we say another example of the Employment Tribunal not doing performing the basic task of any judicial body of enabling the General Medical Council to understand why it's lost, but also in this context, failing to apply the law in relation to who's an appropriate comparator. And then, of course, as the court has seen, I won't spend long on this, in the conclusions section, where you have to look for the conclusions in relation to a number of the matters that, as it were, left open by the discussion under the specific headings, we have paragraphs 107 and 108, which, and I'm not going to read those out because I know you've been taken to those, where the emphasis is very much on the similarities and not dealing at all with the differences.
You say in respect to paragraph 95, even if Mr. Laniardo were a correct comparator, which you don't accept, the first sentence of 95 and the fourth sentence beginning, however, are just not consistent with each other.
Yes, not consistent with each other and not consistent with 73,
Yes.
we say, my lord. So that's all I wanted to say about the reasons of the tribunal at this stage. I know the court doesn't want to be taken through copious lists of authorities, and I'm not going to do so, but may I do this, my lord, which is to invite the court to read the passage in the EAT's judgment where they quote the well-known section of Mr. Justice Elias, who then was in the Ball case, subsequently approved by the Court of Appeal. The relevant passage is at paragraph 113 of the Employment Appeals Tribunal's judgment. That's at
Once
page...
look at it now, as you say, it's familiar, but
Yes.
it's if it's important to your case, do you want us to just look at it now?
Well, if you wouldn't mind, I would be
They
grateful.
probably
Thank you,
should.
my lord. So it's page 99 of the core bundle. And it's an extensive passage, which I'm certainly not going to read out, but if I could just highlight what we say are the crucial parts of it.
Yes.
Really, if one's looking down the internal quotation, paragraph 116, I'd invite the court to sideline. And this is a point I know that's been put to my learned friend, but as Mr. Justice Elias said, in discrimination cases where inferences from primary facts play such an important role, it is necessary for the tribunal to set out its principal findings of primary fact and also the basis on which it has made any inference from those facts. And then quotes Lord Justice Peter Gibson in the Chapman and Simon case. Yeah. Again, familiar, but I'd invite the court to sideline that quotation. And then moving on in the internal numbering of the paragraphs from Mr. Justice Elias's judgment, the next is about halfway down page 100, paragraph 118, where there's reference made to the other Court of Appeal case, this time Lord Justice Pill, giving judgment in the Governors of Warwick Park School and Hazelhurst. It would be good enough just to sideline those two paragraphs quoted there. And then the last crucial passage, we say, is paragraph 122 on page 101. This is back in Mr. Justice Elias's judgment. Perhaps it's important to read the paragraph just before in relation from the Emery-Reinbold case. And the whole of that paragraph, please, 122, if the court would be good enough to read it. What we say those authorities stand for, an uncontroversial proposition perhaps, is it's not sufficient to do what my learned friend does in her skeleton at paragraph 30, which is to invite this court to infer that the Employment Tribunal must have considered the differences between Mr. Laniado's and Mr. Karim's case not to be material. In cases which turn, discrimination cases, matters of great importance to both sides, which depend so much on inferences, as these Court of Appeal authorities make clear, it is crucial that those matters are expressly set out in the reasoning of the tribunal. And they aren't here. That's what I wanted to show the court there. My own friends put in, again, I don't suggest the court goes to it, but put in another authority at tab 20 of the authorities bundle, the Leicester City Council versus Palmer. We say supports the GMC's position to the following extent. So it's tab 20, beginning at page 395, not inviting the court to turn it up. But what the court will see when it does at paragraph 43 is that there are 2 pages there in which the Employment Tribunal, whose
You must know, Mr. Hare, that if you start saying things like that, we have to look. We have to look.
Yes, I'm sorry.
Can't resist.
Well, it's
Begins at 395.
a very long paragraph. 43. This is a decision of
Judge Taylor.
Judge
That's
Taylor.
Taylor, that's correct. Yep. Yes.
Is this really going to be helpful?
Well,
no disrespect to Judge Taylor, but it's an EAT decision. It looks highly fact specific.
Yes, it is. But really, 43. The reason I wanted to show the court 43 is this. Paragraph 43, which is on page 405, runs for 2 pages, and it's quoting from the Employment Tribunal, where the Employment Tribunal goes through each of the differences that the employer sought to rely on as distinguishing the case of the comparator from that of Ms. Palmer, and explaining why they didn't consider those differences to be material. My point is that's simply not present in the Employment Tribunal's decision and reasons in our case. It's that point. It's just a short point. I hope it was worthwhile turning to it, but the court may think otherwise. But anyway, it was more about the Employment Tribunal decision than the Employment Appeal Tribunal decision, really. Thank you, my lord. The next point, and I can deal with these points, as I said, much more quickly now, now that I've got the majority of those documents out of the way. So on to the second and third matters, that is to say the failure to progress exactly the same allegation in relation to the canteen meeting and relying on Mr. Rao in relation to Mr. Karim, even though he was considered to be unreliable. It is important to have regard to the terms in which these allegations were put. The terms, as my Lord Justice Underhill pointed out at the start of proceedings from the list of issues, come straightforwardly from the claimant's pleaded case. So there wasn't any negotiation. This is how the claimant put its case at its highest. And the claimant's case at its highest was the failure to progress exactly the same allegation against Mr. Laniado as was progressed against Mr. Karim. I'll explain why that's significant in a moment, if I may. But the contrast, of course, is with Mr. Laniado's case, which, as we know, was closed in November 2015. And that's where I wanted to take the court to the case examiner's decision in Mr. Laniado's case, if I may, which is GMC's unagreed bundle, beginning at page 120. There are just a couple of passages here I'd like to highlight. So remember, what's being addressed in relation to both of these complaints against the GMC, both relate to the canteen meeting. And we saw yesterday what the Hollywood report said about the canteen meeting in relation to both Mr. Karim and Mr. Laniado. Here's the decision. We see it's dated the 14th of November 2015. under the heading decision, the case examiners, I emphasise that because this is the Rule 8 decision, so 2 case examiners have determined that the case should be concluded with no further action. We explain our reasons below. There are just a couple of passages, as I say, I wanted to highlight, if I may. On page 120, there's reference under the heading background, the second paragraph, to the Maintaining High Professional Standards report dated 15th of December 2015.
So which page are we on?
120.
Oh, 120. Sorry.
Yes. So under the heading background,
Yeah.
second paragraph, the MHPS report dated 15th of December 2015. That's part of the background, summarising that. Seen that already, that's a reference to the Hollywood report. Then under reasons for decision, at the bottom of 120, case examiner sets out the test. You see reference there to the realistic prospect test of establishing a doctor's fitness to practice is impaired. And I'm all coming back to where I started, as it were, yesterday, with that's the test that has to be applied, and that's a holistic assessment. On 121, the second full paragraph, beginning, we have carefully reviewed the evidence in this case, which includes an external investigation commissioned by the Trust into allegations of poor behaviour of medical staff in the urology department, along with the evidence gathered during that investigation. One thing I didn't pause over very much when I showed the court yesterday the Hollywood reports is that, of course, the court only has the textual part of that report. Each of the Hollywood reports has a section at the start, after it identifies the terms of reference, where there's a list of who was interviewed and when, a list of all the witnesses who were interviewed. And of course, the Hollywood reports, when they were sent to the General Medical Council, came with those records of the interviews. So I wouldn't want the court...
Well, oh, I see. I think I may have made a mistake. It includes 2 investigations. So it's the first, the external investigation. That's Miss Hollywood.
That's Miss Hollywood. The first
Yes, I've
one,
marked up the second. The MHPS one is what?
That's
Miss
Hollywood. But there was an internal investigation before by Professor Roche,
Yes.
ROCH.
Sorry, we're at cross purposes. No,
Sorry.
the first one is Roche, and
Yes.
the second one is Hollywood.
That's correct.
Yes, that's what I thought.
Yes.
But what you were saying about the evidence gathered during that investigation, you were emphasising particularly the evidence gathered during the Hollywood investigation.
Yes.
Yeah. So, no doubt both.
Uh,
Which, as you say, we haven't seen.
No, but the Employment Tribunal did.
Yeah.
It was, and it was a list. Or it wasn't a list, sorry. There's a list in the Hollywood report which you have, my lord. What you don't have are all the actual interviews.
Yeah, they were appendices.
Precisely. Yes, that's exactly right. So when the case examiners are saying they looked at the evidence underlying the report, they weren't relying just on the report.
Yeah.
And the evidence gathered during that investigation. We note the outcome of the MHPS investigation into 4 of the 5 concerns, that of course included the canteen allegation in relation to Mr. Laniardo, that the evidence does not support them. We have reviewed the evidence and agree that these allegations do not meet the realistic prospect test evidentially. So they are the case examiner's reasons adopting, but not simply rubber stamping, the reasons given in the Hollywood report and based on the evidence there relied upon. No comment on Mr. Rao's credibility in the case examiner's decision to close the canteen meeting allegation, even though the third particular is that when communicating to Mr. Laniardo the outcome of his investigation, GMC investigation, according to the particular 3, the GMC said to Mr. Laniardo that Mr. Rao was not credible. Well, it's simply not there. And the date's wrong. The particular refers to 2016, it's 2015 this decision was made. There was another case examiner decision in 2016, you've got it in the, we put it in the bundle for completeness, it's at 125 to 129, related to a clinical concern about Mr. Laniardo. Nothing to do with Mr. Karim. So in the tribunal, in adopting that, to the extent that it did, fell into further error. While I'm on this, I thought the most efficient way, but I'm in your Lordship's hands, but while I'm on the closure decision in relation to Mr. Laniado, I wonder if it would be sensible just to refer briefly, I think you've seen it, to what the case examiners decided in relation to the MDT letter. I'm pretty sure my learned friend showed you this, but just to make sure the tribunal realises there was one outstanding matter after Hollywood, as it were. Well, they're all outstanding, but one matter that wasn't adequately resolved by Hollywood and the evidence she obtained, and that related to the MDT letter. Remember, that was left open. And 121, we see what the case examiners said about that, a little over halfway down the page, italicised and underlined. It is alleged that Mr. Laniado signed an MDT letter, knowing that the information contained in it was false. I'm not going to read out all of the background there. But in terms of whether Mr. Laniado, as it were, got an easy ride because he was white, if we look at 122, halfway down, I hope I'm not skipping over this too fast, but I'm just trying to save a bit of time. There's a paragraph which begins on 122, halfway down. If it could be proved to the required standard, does the court have that?
Yeah.
Yes.
That Mr. Laniado signed the letter, knowing its contents to be false, this would amount to a significant departure from the standards expected of doctors, as set out in the GMC's publication Good Medical Practice. So there's no sense, we say, in which the case examiner minimising the significance of signing, even though one might legitimately think it's more serious if you draft the letter and then encourage others to sign it, or even seek to intimidate them in order to sign it. But nonetheless, there's no sense in which the GMC has minimised the seriousness of signing it if you don't believe that it's the case. But then the next paragraph is the crucial one. I'm not going to read all of that out because I'm fairly certain my learned friend took me to it yesterday.
Yes, you did.
2 points. 13 other members signed it, along with Mr. Laniado. And the histopathology report now supports the diagnosis that it was urethral. In other words, there was nothing untrue in the letter, and there's no realistic prospect of demonstrating that it wasn't discussed. 13 names from members of the MDT. Mr. Laniado's case, as we saw throughout, was initially he couldn't remember signing it. Then he did remember signing it when he was shown it. And he said he signed it because his recollection was it was discussed and it was a urethral cancer patient. So that's why that matter's closed. As it was, of course, in relation to Mr. Karim, when the histopathology report was available. The difference in timing about the closure decision arises simply from the fact that Rule 8 decisions are only made at the conclusion of the investigation. And for Mr. Karim, so that's all I was going to say about that document. I'm just pausing for a second in case the court has any questions about it before I go to the Rule 8 decision in Mr. Karim's case. But
Do we have the date of the histopathology report?
no, I'm sorry. I'm sure we
No,
could
that's
find
all right.
that.
No. Just
So it must have been after the Hollywood report
Yes.
and before the November
Yep.
of 2015, but I'm afraid I can't help anymore.
It seems rather hard on somebody in Mr. Karim's position that when this issue is cleared up, he has to wait quite a long time to be told that there'll be no action on it, simply because there are other issues in play, and it doesn't seem to be the practice of the GMC to tell registrants, well, this investigation is still open, but we can tell you that this potential count, as it were, has been put to bed.
No. Well, that's only putting it to bed can only be done by the case examiners.
Yes.
Under Rule 8. So.
Yes. Well, why don't the case examiners say we're not proceeding further on this allegation?
Well, I can't answer that, Harold. That's certainly not the practice, but it's not the practice in relation to doctors of all races. That's the point. For the purposes of this case,
yes.
Of course we accept, and my Lady Justice King made the point yesterday, of course General Medical Council accepts the stress that it places on doctors when they're subject to investigation. We haven't got any of them in the bundle here, but and the court may decide this is cold comfort, but all of the GMC's letters in the course of investigations when they're updating doctors say, we understand how stressful it is to be subject to these processes. Here are helplines and support services that are available to doctors who are undergoing these investigations. But I'm sure, of course, your Lordship's words will be heard by those sitting behind me, but we say it's not a matter that can affect the outcome of this case. There was a substantial delay for Mr. Laniardo. The Hollywood report in December of 2014 said about him there was nothing in relation to the canteen meeting, for example, and 4 of the other 5 allegations, of course. They remained open as far as the GMC was concerned and subject to investigation until November 2015, almost a year later. So he also suffered the stress there. So that's the point about the case examiner's decision in relation to Mr. Laniardo in November of 2015. The case examiner's decision under Rule 8 in relation to Mr. Karim, in relation to this question, the MDT letter, is at page 67 of the GMC bundle. Obviously, the decision begins earlier. The decision begins at 56. And I'll have to take the court back to that in relation to the canteen meeting. But for the MDT matter, the court could turn, please, to page 67 of the GMC's bundle. There's a heading about halfway down the page there, in italics, issues covered by the local investigation, but which were not included in the GMC's letter of 31st of March 2017. GMC's letter of 31st of March 2017 is the Rule 7. I didn't take the court to Rule 7 because I don't think anything turns on it in this case, but it's in the rules, obviously, and the authorities bundle, tab 2. Rule 7 is the point at which the GMC puts the allegation, the draft allegation. Yes, I see your lordship's nodding, so familiar with that. And that was...
No, well, I wasn't finished your sentence, I think.
Yes. All I was going to say was that's the point at which the investigation ends and the allegations are put to the doctor, and then the GMC, there's a time limit, of course, for the doctor to put in their reply. And then when you have the doctor's reply, you then get your referral to the case examiners. That's for the decision whether to close, as in Mr. Laniardo's case, as we saw, any of the other outcomes under Rule 8, or refer to the MPT. In Mr. Karim's case, as we know, some were referred, and I'll come back to those. But here, just under this heading, we see the reference to the MDT letter. It's been alleged that Mr. Karim influenced or manipulated the urology multidisciplinary team members to say that Mr. C is the patient, penile/urethral cancer patient. Sorry, I'm sorry.
Yep.
Mr. C is Mr. Motawala. I'm sorry. The patient is DG. Was discussed at the MDT meeting. So then there's a significant amount of narrative, but we then see over the next page, 68, a short passage. The expert says, so that's the expert histopathology report that was referred to in relation to Mr. Laniardo, and under that, back to the case examiner's decision, this is relevant to the allegation against Mr. Karim, and that it means that the clinical issues and the appropriateness of treatment mentioned in the letter were not false. This leaves a possible allegation that Mr. Karim bullied staff into signing a letter containing information that he believed to be true, as there is no evidence to suggest he believed otherwise. That's then addressed. And then on 69, at the top, however, there's no cogent evidence to suggest that Mr. Karim bullied staff members into signing the letter. Again, looking at the evidence. In these circumstances, there is no realistic prospect of establishing the doctor's fitness to practice sufficiently impaired to justify action or registration in relation to this element of the investigation. So again, MDT letter closed.
What's the date of this, Mr. Hare? Sorry, you did say it. But...
I did, and it is the 29th of September 2017, my lord. that's 2. There's one part of 3 left. I've mentioned it already, but I just wanted to make sure that the court knew what I was saying about it. So 3, you'll recall, despite forming the view that Mr. Rao was unreliable, conveying that view to Mr. Laniado, proceeding with the allegation against Mr. Karim. So I just wanted to show the court what the case examiner said about that. So it's the same document. That is to say 56 to 71. If we go back to the start of it, please. On page 56. You'll see the date, my Lord Justice Bean's question there, 26th of September 2017 at the top.
Yes, they're rather oddly, well, not oddly, understandably. The actual date of the case examiner's decision is 3 days earlier.
Yes. Yes.
If we see that at the top of page
Yes.
57.
Yes.
In fact, it is a very elaborate system. This is from the investigation officer enclosing a letter from an assistant registrar,
Yes.
which we haven't got,
No.
confirming the case examiner's decision,
Yes.
which we have got.
Yes, but the enclosures to the assistant registrar's letter also include the case examiner's decision.
Yes, okay. Just,
And we see the decision itself there at 57. For reasons given below, the case examiners have decided to refer the matter to a medical practitioner's tribunal. So that's the Rule 8 decision. Background is set out. I'll go through this swiftly because the court is very familiar with all of this now. The local investigation and the allegations there. And on 58, under those allegations 1 to 5, the local investigation concluded that there was a case to answer in respect of some but not all the allegations. However, before matters could proceed to a disciplinary hearing, Mr. Karim resigned from his position in the trust. Then 58, halfway down, reasons for decision, sets out the test again, the realistic prospect test, so the equivalent to the passages we saw in the earlier decision. And then we come on at 60, this is important we say, so the matters considered to raise questions of impaired fitness to practice, does the court see that? It's just before the numbered section, were put formally to Mr. Karim in the GMC's letter of the 31st of March 2017. So that's the Rule 7 letter I referred to earlier on. And these are how the allegations are put, probably familiar, but a series of what are called particulars of the allegation, that being registered, because obviously as we saw section 35C only applies to those who are registered. Then 1, 2, 3, 4, I'll come back to 1 obviously in a moment. But then at the bottom, on page 61, under 6B, and that by reason of the matters set out above, your fitness to practice is impaired because of your misconduct. That all comes back to the test I was describing earlier on. But if I could invite the court to, having taken it as it were out of sequence slightly there, back to page 60 for the particular allegation here. What was put to Dr. Karim? And the reason I emphasised earlier on, proceeding with exactly the same allegation. That was the claim that was made on behalf of Mr. Karim in the ET1 that made it into the list of issues and that was addressed by the tribunal. By the time the matter proceeded to the MPT, as the court sees, the allegation in relation to Mr. Karim was very different from anything that was ever indicated about Mr. Laniado, because we see from 2, on January 16th, 2014, you stated to Dr. A that he should repay you money that you had previously provided him as support towards his postgraduate training in the presence of other clinical staff, all words to that effect. And 3, your actions at paragraph 2 were inappropriate in that you intended to threaten Dr. A, b, intimidate Dr. A. And where we see those very different allegation, the emphasis on the way it was started, the ambush, as Dr. Kelsey described it, as the court will recall, we see then 62 to 63 is where the case examiners address that. I'm trying to save a bit of time. I'm getting on quite well, I hope, in terms of time at least, if nothing else. But I don't want to read all of that out. But would the court be good enough to sideline from Mr. Karim seems to have appointed himself as some sort of private investigator Does the court see that on 62?
Down to where?
Down, I'm afraid, all the way to 63, above the next matter, the alleged attempt to intimidate Dr. Robinson.
Well, let's just cast our eye over that.
Yes.
Yep.
Thank you very much. And can I just remind the court what the Employment Tribunal below said about that at paragraph 73. That's page 123 of the core bundle.
Paragraph and page.
123, my lady. Paragraph 73.
Yeah, that's what you showed us earlier.
I showed you earlier, but can I just show you or emphasise the second part of that paragraph? So we see 4 lines down, the conclusion of the tribunal is that there was no less favourable treatment in referring this matter, along with the other matters, to the MPT. The MPT saw and heard witnesses. Up until that point, there had simply been a paper exercise by the case examiners. The claims were considered potentially serious. In allowing them to proceed to the MPT, there was no less favourable treatment. And of course, the fact that that allegation, or that particular of the allegation of impairment, wasn't made out was because the witnesses relied on by the general manager, not Mr. Rao, as we know. I spent a long time emphasising that yesterday, so I won't do so again today. But Mr. Kelsey and Mr. Laniardo, their version of events was not preferred. That's a clumsy way of putting it. Mr. Karim's version of events was preferred when he gave live evidence for the first time, which he did at the MPT, having made a number of admissions about the way in which he understood now how his comments and approach could have been misunderstood by Mr. Rao. So it's just a completely different picture, of course, by the time you get to the MPT. But the crucial point here is we're talking about the earlier stages where we've got the triage decision and then the case examiner's decision before that evidence has been tested in the forensic process. So that's all I wanted to say about items 1, 2 and 3, as it were. I was going to say something about the statistics, but I said that yesterday.
Yes.
Because I took the court to fair to refer to the inquiry, the Plymouth University inquiry, and the conclusions of that inquiry, and dealt with that, I hope, yesterday. What it demonstrates, we say, just to recap, is 2 things. 1, there is overrepresentation, as I said, across the board among healthcare regulators and indeed other regulators. 2, the explanations for that, as far as the quantitative analysis are concerned, are, unsurprisingly, that it's complex, it's complicated. Of course it is, because it's multifactorial. And there's only so much that the statistics, the bare statistics, for example, on ethnicity, can show you. If you get more granular into the statistics, you reveal a whole series of other, sometimes more surprising differences or disproportionalities in referral rates and investigation rates. Male doctors are much more likely to be investigated. Older doctors are more likely to be investigated. Doctors in certain disciplines are more likely to be investigated. The common theme throughout, and of course there's a very significant overlap here with the ethnicity data, is that if you are an international medical graduate who qualified outside the UK and outside the EEA, you are most likely to be investigated. Now, that could found a case, you might say, an indirect discrimination. Not our case, of course, because Dr. Karim is a UK qualified doctor. But the question then would be how you would justify that outcome. It's not a case for this court. But the only point I'm trying to make, without running hairs running that aren't relevant, is that it sounds like a fudge to say it's complicated. But I'm just trying to summarise really what those hundreds of pages of research by academic teams of researchers produced. And the point we make about it is you simply cannot go from the bare statistics to the inference, we say. What you certainly cannot do is go from the bare statistics to an inference without considering the quantitative research, which was such an important part of the General Medical Council's case. And as I said, it's a number of paragraphs of our closing submissions below. The only other point I make about that, before I move on to the question of delay, is that if that is correct, if it is the case that the General Medical Council has been producing these statistics, commissioning this analysis, and it has been since the 1990s, you haven't got all of these before the court, but the court may recall that some of the research says for the past 20 years it's been noticed that there's this overrepresentation. GMC has been commissioning quantitative research into its processes from the 1990s, all of which, and it's still ongoing, there's another report you don't have from 2021 from the University of Edinburgh, all of which have concluded that the GMC's processes do not contribute towards that overrepresentation of doctors, either in investigation or in outcome. And if that is right, then it puts a very different shade on the Employment Tribunal's conclusion that they considered the General Medical Council's witnesses to be complacent about that. Of course, it's never
sorry, this is...
Forgive me, Mr. Hare.
Yes,
which review reports did the ET have before them? You mentioned the Plymouth report, which is in your bundle, pages 131 to 211.
that's correct.
And also, there was also fair to refer, question mark.
Sorry, just before you leave that, there's just a one-page summary of it at page 130 in the same bundle. That's a different inquiry from the year 2000 called The Handling of Complaints by the GMC. That was also before the ET. And
What, the one-page summary or the full?
No, the one-page summary was before. Yes, the one-page summary was before. It's the conclusions section. It's all, I'm afraid, that we were able to find at the time, but it was before the ET. And as you say, my lord, fair to refer, which is in
we've got in the other bundle.
Claimant's unagreed bundle, was also before the ET.
Which is full of footnotes and references.
Full of footnotes and references and so on, yes.
But in terms of the evidence which you put before the ET, which they didn't address, it's essentially the Plymouth report and the one-page summary of the earlier report.
Yes.
And arguments based on them.
Of course.
Which
But
say,
it's
if we look at the closing submissions, we'll see them all.
Yes. It's principally the Plymouth report because its choice of case analysis fell within the period that Dr. Karim's case was going through the GMC, or very close to it. So the earlier one, 2000, of course, was not relevant.
But just remind me, we did ask this yesterday, and you probably answered it, and I've forgotten. The actual figures that appear in paragraph 99, I think, I'm not sure where they, is it 99? Yes, where they came from.
Well, my learned friend will help you with that because she's produced a short clip, and I think she's going to talk to you about it when she starts her reply. But
yes, that's right. We asked that there was a reference to something called D181, which we hadn't got.
And you've got D181 in the clip that my learned friend will shortly hand up.
Okay, right. Well, that's helpful. So we'll wait to hear what she has to say about that, and hopefully you won't have to say anything. But if that's new, you may have to come back on that.
Yes.
Right, thank you.
Delay.
Delay.
I hope I can be fairly swift on this. There are 3 points, really. They all come down really to the same thing, which is we say the tribunal erred in taking a critical view of the delays in Mr. Karim's case and instead of focusing on the question of what evidence there was that race played a part.
Is this the first of your 3 points, or is this
This is my overarching point.
Yes, I see.
Yes. Instead of focusing on what evidence there was that unconscious race discrimination contributed towards those delays, the tribunal undertook a review of the reasons the GMC advanced to justify the delay. Now, that sort of exercise reminded those at the GMC of the sort of exercise one sees when an employment tribunal reviews a disciplinary process by an employer which it thinks has been subject to undue delay in determining general questions of reasonableness and general questions of fairness, which of course are properly before an employment tribunal in an unfair dismissal case, but not here. So that's the overarching submission. The crucial points, so now I'm moving on to my 3 points, my lord. The first of which is, I know the court has this point, there were no statistics on delay to suggest that black and minority ethnic doctors' cases took longer to get through the GMC's system. You might think it would be the opposite if actually there was any, certainly if there was conscious racial motivation, because if you're trying to get to sanction and stop them practicing, you might want to accelerate that process. But in any event, that's an aside. The point is there is no evidence. What was the only other basis upon which the tribunal below relied in relation to drawing its inference? Comparison. There was no comparator identified in relation to delay, and I've already explained that there were significant delays in the one comparator the Employment Tribunal did deal with, and that was Mr. Laniado's case. What the tribunal does instead, as we see it, paragraph of the Employment Tribunal, paragraph 81 of the Employment Tribunal's decision. Yes, paragraph 81, I do apologise. Headed, the tribunal's conclusions are that the overall delay, the apparent tenacity and investigation of peripheral complaints, I'll come back to that, require explanation. So the tribunal, having looked at the GMC's reasons and not thought much of them, goes straight to, we say, putting the burden on the General Medical Council to explain the racial discrimination, or the inference it's drawn of racial discrimination, without identifying any basis for saying there was a race element to it, consciously or unconsciously, other than saying we don't like your reasons. And that, we say, well, that's the second point. I'll come on to that in a moment, perhaps. And what's crucial, and that's why I wanted to show the court the Ball case, and the cases referred to in it, is where it is, as one has here, a case of unconscious bias based on inference. It is of the essence, we say, and that's what the authorities say, that the tribunal sets out its findings of the basis of the inference. Can I say something? So that's the first point. Second point is, in relation to the delay itself and what the tribunal said about it, I just wanted to make a few short points. The first is, if we look at paragraph 110.
So what are these few short points you're going to demonstrate? That the delay wasn't as bad as it appears. All right.
I'll be very brief, my lord.
Okay.
Paragraph 110. And there's reference elsewhere in the judgment to the case taking more than 3 years. In fact, we say, and I don't think this is disputed because it's in the agreed chronology, that the GMC investigation, as we know, didn't start until the conclusion of the trust investigation. That's what happens with all GMC investigations. That's, as we know, in March of 2015. Sorry, it's in May of 2015, I apologise, May 2015, that the trust concluded its investigation. It concluded because, of course, Mr. Karim said, I'll go. So they didn't carry on with their disciplinary process. So that was when the GMC's investigation, it had been opened, the GMC's investigation itself began. It ended, and that's why I've emphasised this date several times, 31st of March 2017, again you see it in the agreed chronology, investigation into Mr. Karim ends and draft particulars of the allegation are sent to him. So that's the period in which there's I'm not saying that's a short period, but it's under
Just give me the dates again.
So from 27th of May 2015 until the 31st of March 2017.
Not a short period.
Not a short period, my lord. I don't suggest it is. But if you look at 110...
Then how long actually until the...
That was another year. Until the
That's
conclusion of the MPT.
Yes, right.
That's not the investigation.
Yes, I see.
And the allegation was about the investigation and the length of the investigation. The impression one gets from reading 110 is that the Employment Tribunal are really criticising the GMC going back to October 2014, because that's the first date they refer to there, when the Roche report was received. So the delay we say wasn't...
At least me, that isn't a very long time. Your real point is, what's it got to do with race?
Of course. And I'm not suggesting it's not a significant amount of time, but it's not as long as the tribunal might have been suggesting. Can I then make the following very, very short points about the question of what was being done?
This is all under the general heading, which I put, my words, not yours, delay not as bad as it seems.
Yes.
Okay.
And one of the
What
points
else?
that the tribunal made was that it suggested that from 2015 nothing was done by the GMC at all in trying to progress the investigation. Let's make these points. First, of course, there was the histopathology report that we know came out in relation to the cancer patient DG. That was post that period. There are then the inquiries at the Spire. I'll have to come back and say something else about that. The ET accepts at paragraph 82 that wasn't resolved until December 2015. And then there was the reverse engineering the email allegation, which did go to the MPT. That wasn't reopened because it had been missed. It was in the Hollywood report, but it had been missed by the first investigation officer. When a new investigation officer was appointed, he spotted it, and that had to go through the process of being reviewed and reopened. That was August 2016. But the key to the delay, I'll deal with this very briefly just by reference to one document, my lord, was the fact that Mr. Karim's case was linked to Mr. Motowala's. The investigation was linked to Mr. Motowala's. You can see the link.
Well, we know. Okay, right. Yes.
From the agreed chronology.
Yes.
Because you see where the letter investigation into Mr. Karim ends 31st of March 2017, 4th of April, 4 days later, investigation into Mr. Motowala ends.
But everyone agrees it was linked to Mr. Motowala.
Yes.
You don't need to.
No. Okay. But what? So the question then is, why did that cause delay?
Yeah.
And I've put in the bundle. We've put in the bundle. GMC's unagreed bundle, page 53. I shudder to think how it's come out in your lordship's printed and your ladyship's printed copy, because I'm looking at it electronically and it's a big landscape document.
Page 53 of which?
Of the GMC's bundle. That was what I feared. It's all on one. I'm sorry about that. We can, of course, produce a larger version if the court thinks it's helpful. But can I just say why we've put it in and what we say it shows? The crucial thing is that on the first layer, I don't know if it's possible to see, there's a box under the heading investigating, which is the third box from the end. I don't know if that's legible. In the oval
Speaking
boxes.
for myself, all I can see is some coloured blobs of varying colours.
Right. The top
Minuscule font.
Top row of coloured blobs, 3 from the end, 3 from the right, is headed investigating, and under it is a box which has a series of initials, and it's headed care provided to 15 patients, and they're the initials of the patients. And then below, there's another
Sorry,
one.
what's the point you're making? Is the point you're making that the Mr. Motowala investigation was a very long investigation because they had to investigate the cases of 15 patients?
And another 12 patients further identified there. My lord, the point is this. Mr. Motowala was unwell. the GMC decided that rather than what you'd normally do, his case was one of misconduct and deficient professional performance. Rather than putting him through the trial of a performance assessment, which indications were he would not be able to cope with, in his case, the GMC had to proceed in relation to all of these 27 patients by getting all their patient records and then getting expert reports in relation to them. Now that inevitably takes a long time. That's the only point I was going to make about the link. And the crucial point about the link, as the Employment Appeals Tribunal pointed out, it wasn't challenged, it wasn't suggested that despite the 20 particulars of discrimination, that the decision to link Mr. Karim's case to Mr. Motowala's was one of the particulars of discrimination. And there's no basis identified, although the tribunal criticises it as a matter of convenience for the GMC, there's no basis identified for it being discriminatory. Well, that's what we say about that. The third point, that was my second point, the third point on delay, and I'm just going to invite the court to look at this, is not now, is that we say the approach the tribunal took, which was to, as it were, dispense, we say, with the first stage of applying the burden of proof provisions, which require the tribunal to put out of its mind the respondent's explanation for the treatment. Look at all the evidence, but they shouldn't consider the explanation. And in this case, the tribunal did the opposite of that. They went straight to the GMC's explanation, criticised it, and then said, because we don't accept it, well, I'm paraphrasing, we don't accept the GMC's reasons, we infer discrimination.
So they should have asked themselves first, subject to any investigation, subject to any explanation, can we infer discrimination from the mere fact of the delay? And they didn't.
No.
And if they had asked themselves that, it would be perfectly obvious they couldn't, because delays have nothing to do with...
Precisely, that's what we say. So the phobies, I'm not going to invite the court to go there, but tab 17, it's paragraphs 22 to 23 and 40 of Lord Legate's judgment.
Which paras?
22 to 23 and 40.
And that really just repeats, yet again, what we've known ever since Madarasi and possibly since Aijin.
Yes.
Yeah.
Okay. It does qualify one aspect of Madarasi about taking account of explanation. But anyway, I won't say any more about that, but the court will no doubt read it. That leaves me with just one matter to deal with, my lord, and I'll do it very briefly. And it's the sort of the lingering matter of the Spire allegation.
Well, two things, I think. What about absence of any diversity training, or not sufficient evidence of proper diversity training?
Yes, well...
Ms. Monaghan didn't put a great deal of emphasis on that, but she did nevertheless mention it from time to time.
Yes. Well, all of the witnesses, and we see they're described, paragraph 100 onwards, had diversity training, and it's referred to there. That what the tribunal criticises, or my own friend criticised some of them for, was two of them, I think, had not had specific training, or couldn't remember having specific training on unconscious bias matters. So there was diversity training, continues to be diversity training at the General Medical Council. The equal opportunities policies matter was one upon which the tribunal doesn't actually reach a conclusion, because my own friend criticised the General Medical Council for not having equal opportunities policies. Of course it has those as employer, but it wasn't being sued as employer. It was being sued as a qualifications body. So we didn't put in the General Medical Council's equal opportunities policies because they weren't relevant to the function that the General Medical Council was discharging. But what we did put forward were all of the, upon which the GMC witnesses spoke as to their training, of the research the GMC has done into the disproportionate referral of doctors and their disproportionate...
Yes, I see. So what you've been referring to as earlier in connection with the statistics really feeds into this point.
Precisely. So that's that.
There is some law, isn't there, that says, but this is any common sense anyway, that absence of or inadequate diversity training doesn't get you very far. It's something that may go into the mix, but you've actually got to look at the facts of the particular case. I think it may even be a decision of mine, which is probably why I remember it. But as a proposition, it seems subject
right
to Respondent. I think it's a case called Natfi and De Silva, but it may not.
Yes, I did cite that actually, but yes.
If it isn't, I or somebody else has said that.
Yes.
And so unless Ms Monaghan wants to suggest otherwise, it seems pretty obviously the case.
Yes. Yes. So, my lord, that just leaves, subject obviously to the court's questions, but that just leaves me to deal very briefly with the spy matter. Briefly because, of course, it wasn't found against the GMC, so it's not a particular. But my own friend says it was part of the context and the Employment Tribunal was entitled to take it into account. And they do refer, and we've been to it earlier today, they do refer, the tribunal that is, do refer to what they describe as the tenacity with which the GMC pursued a matter even after the spire had informed them that they had no concerns about Mr. Karim. And I just wanted, because it didn't come through in the summary that my learned friend took you to, I just wanted to make sure that the court had the relevant documents there in relation to it. The overarching point is this, my lord. It wasn't a case of the GMC saying, let's grub around and find what we can. Spires come back and said, Mr. Karim didn't try and get rid of Mr. This is the Mr. Palm Sandu question, you'll remember. And the Medical Advisory Committee. It wasn't a case of that. The GMC asked the spire about it, and the spire said in August that we have no concerns. And that's the letter that you do have in the claimant's bundle, this is, the claimant's unagreed bundle at 58 to 59.
We were taking that, weren't we?
You were.
Yeah.
Could I just take you back to it very briefly? This is a document, a letter, page 58, from Spire Healthcare, from Mr. Dr. De Gorta, who's the Group Medical Director. We see that on the following page. It's dated the 7th of August 2015 to Miss Gately. Further to your letter, point E of the letter states, the allegation Mr. Karim influenced or manipulated the MAC, the Medical Advisory Committee. It says there, we have investigated this accusation and would like to state the following points for clarity. Then the points are set out. Now, and the criticism appears to be the criticism of the Employment Tribunal, and certainly the criticism of my own friend there, was, well, why was the GMC then going back again to them, 78 to 79, in November, asking for further information about it? And if we look at 78 to 79, same bundle, we see that all the GMC was doing, we don't have the GMC's letter of the 12th of November, but we can see what it was about. It was a request for further information. That's what it says. Dear Ms. Stelfox, our different investigating officer, 16th of
Why
December.
is that an answer to the criticism?
Sorry, I'm coming on to that.
Oh, sorry.
Yeah. In respect of your request, 12th of November, for further information, I'm able to provide you with the following. The documents, the minutes from the MAC meeting, the list of individuals on the MAC, a summary of the concerns raised in relation to Palm Sandy, and so on. So all the GMC was doing in going back to Spire was asking for the underlying documents, in the same way that it did in relation to the trust investigation. It didn't just accept a letter from the trust, it requested and obtained the Hollywood report and the evidence which underlay it. So we say it's quite unfair to say that that is, and wrong, to say that that is the GMC being tenacious in trying to get Mr. Karim for something. They're just wanting evidence so that they can confidently say that there is no issue there. And without going into wild realms of speculation, there might be all sorts of reasons why the spire obviously had a dispute with Mr. Sandu and moved him to another hospital. There might be all sorts of reasons why the spire didn't want to be very open with the General Medical Council about those circumstances. So the GMC asked for the underlying documents. That's all there was to it. And once those underlying documents were received, as we know, this matter wasn't pursued any further.
It takes 3 months to ask them.
Yes, it takes 3 months. I accept that, but there we are. I'm sorry about that.
There was another document, I think. If we go back to 58,
Yes.
at paragraph 2 it says he accepted a similar post at a hospital closer to his home.
Yes.
And nothing to do with the removal in inverted commas. I mean, that was slightly dumbing down what had actually happened, because there was another document, not the 78, page 78, not the page 58, I can't remember where it was, that you took us to yesterday, or perhaps Mr. Wonder, someone took us to yesterday, which actually describes a bit more of what happened and that he'd been put on gardening leave.
Yes.
And it had been resolved ultimately by sending to a different part of the country. So actually, that letter was rather vanilla.
Yes. Yes. Well, in any event, you have my submissions on that, my lady. We say it's all legitimate. Unless there are any other matters.
Not as far as I'm concerned.
On paragraph 81 of the tribunal's conclusion on the overall delay, and the apparent tenacity in investigation of peripheral complaints require explanation. And that, when I first read that, I thought, is this going to lead to a finding of bad faith? But I don't think it isn't really pursued, is it?
No, I don't think so.
No. Thank you, Mr.
Thank you very much.
Yes, Miss Bonner, you've got some more documents for us.
I have very few, I'm happy to say. May I just hand them up in one? Well, I can hand them up now, but I'd like to deal with it in one moment. Take them in order.
Well, all right, but I'd hand them all up now.
Yes. And they're to go behind at the back of the appellant's supplementary bundle, so the unagreed bundle.
Keep calling them the unagreed bundle. I mean, they are now in practice agreed on both sides,
Yes.
aren't they?
I'm sitting...
Well, hang on, just give us a second to put them in. They're numbered to help them.
Yes, they are. And they've got the tribunal numbering on as well, so you can see how they fit
This is going
into our bundle at the very back.
Yep.
Thank you. If I can then please just pick up first of all where Mr. Hare picked up, and before I do so I should say I'm standing in the middle of the row almost, because the chair's broken there and I sink under the row. I'm already short, so I find myself almost on the floor.
We hadn't noticed, but I'm sorry.
Not at all, not at all. I just
and we will
wondered, I didn't want you to think I was taking centre stage for any other reason.
We'll ask the usher to make a note of that. Which chair is it?
It's this one. It
Right,
just
okay.
falls right down.
That can be passed on to
Thank you.
whoever is responsible.
Can I start then, please, with where Mr. Hare started, and that's with the statutory scheme so far as the GMC is concerned. And this is relevant to the issue of delay. Could the investigation into Mr. Karim been brought to an end earlier, notwithstanding there were outstanding matters? If I can ask you, please, then to turn up the authorities bundle. I'll make this point good, I hope, or endeavour to, when I deal with a piece of evidence as well. So this is the start rather than the end. If I can ask you then to turn to tab 2 at page 49. These are the rules.
Yeah.
And you have the rule 4.1, and that's what we've come to know as the triage decision. So it will be considered by a registrar in the first place, and then it will be brought to an end or sent off to a case examiner. And we see, please, at rule 8, that's page 51.
Yeah.
Rule 8.2, upon consideration of an singular allegation, the case examiners may unanimously decide that the allegation should not proceed further. So we're there in the singular. There's nothing in the rules itself that requires a one-off final decision. And then please, if I can take you to the evidence in relation to Mr. Laniardo. So no requirement not to terminate or make a decision in relation to an allegation until the whole of the investigation is finalised. And then if I can ask you please to turn up the claimant's bundle at page 62.
Yes.
We see there a case referral form, so it's sent to the case examiner for consideration, curve template, and I've forgotten what that stands for. We've seen it elsewhere. Mr. Hare might be able to help us with that.
This is C62.
It's page 60 and 61 starting at the claimant's bundle. That's my fault, I beg your pardon. I'm looking at my notes probably as to where to take
Don't
it.
worry.
Starts at page 60. Yeah. So it's we've seen it before.
I see now. It's a curve template. Yeah.
Exactly. And then if I can ask you please to turn to 62, so that was my fault. The document's dated in the original index, just for your note, my lords and my lady, as 12th October 2015.
Yeah.
And we see there under employer, so 4 or 5 rows down, Frimley, and then a triage decision, not adverse, so not past the triage decision threshold, and then AR, and then it says new case set up or retained here, and then it says not adverse except SQ and JP, which we will rate for the trust reports before making a decision, if these are opened, and so on. It then carries on and concludes, as we already know, so far as the case examiner is concerned in due course, by a decision, which I'll take you to now, concluding that MDT and CJ could be brought to an end, could be closed. So if I can ask you please to look at page 120 of the Respondent bundle. I can take this shortly because we've seen it, I think, more than once, but just to follow through the chronology. We see there 120, 14th of November 2015, and we see the Laniardo and the CJ decision concluded. So we have 2 concluded, no requirement under the rules to deal with them in one go. The curve document indicates that though 2 complaints have been triaged, that doesn't prevent, and does not prevent, in the end, the MDT and the CJ matter being dealt with. And then if I can ask you please to look at 125 to see what happened next. I'm sure that's not a typo or oversight or something of that sort. We see at 125, dated September 2016, that the SQ allegation, that is the allegation referred to in the curve document, that had been triaged and so form part of the same document, is dealt with separately in September 2016. So the short point I invite your lordships and your ladyship to take from that is there's nothing in the rules that require a case examiner to defer any decision until the whole of an investigation is concluded, can deal with it allegation by allegation, does so in relation to Mr. Laniardo, notwithstanding that 2 other allegations have been triaged. That's the short point.
So it would be open to the tribunal to find that that was a difference in treatment which has not been satisfactorily explained and is therefore indicative of discrimination.
Yes, it wasn't pleaded as a particular complaint, but this is one of the matters that has been explored briefly, but I'm not sure in sufficient detail given some observations that have been made by Mr. Hare. In my submission, of course, one can deal with background matters. So, for example, in relation to delay, the case for the respondent has continually been there was delay for various reasons, including the fact, in dealing with particular allegations, that we couldn't deal with them finally, even if we knew, for example, in relation to MDT that it was resolved some time earlier, we couldn't deal with it finally and come to a close until the whole of the investigation was concluded. So the tribunal had to make a judgment about that. Was that right? Does that excuse the delay? There's some other reason for the delay. So it doesn't need to be a particular of discrimination. It can be a piece of evidence relied upon to undermine, support, as the case may be, what the respondent says or what the claimant says. And in particular, when one looks at Qureshi, which I know your lordships and your ladyship will be very familiar with, makes it clear, Lord Justice Mummery, and cited in Anya, of course, makes it clear that one doesn't need to treat every factual allegation as a complaint in itself for it to have any value.
But the real point, I understood my lord to be making, is can the failure to split off the allegations and deal with and put some to bed earlier than the rest be even as certainly it can't by itself be a particular of discrimination. I put that badly. It can't justify a prima facie inference of discrimination.
Not by itself, no. And maybe that relates to my next point, if I may make it now, because it, I think, follows through. When one's dealing with, is this an explanation at the first stage, one is looking to make primary findings of fact. Those primary findings of fact necessarily overlap on occasions with the explanation. If a claimant says this happened and the respondent says, no, you're wrong about that because X wasn't even at work on that day, that of course is a rebuttal to any allegation of fact upon which a tribunal might have to make a finding, but might also be an explanation.
Yes, that maybe says one of the extreme complications of the burden of proof rules, but we're not worried about that here. Nobody's taking any point about that here, are they?
Well, save that, it's said that at the first stage, when dealing with delay, so linked to Mr. Motiwala, forgive me, had to wait to the end of the investigation to make a closure decision in relation to any of the allegations and so on. Findings of fact have to be made in relation to those. And then, of course, they're fed back into the explanation question.
Yeah, well, I dare say, but I mean, so what?
Well, the tribunals make...
Came out ruder than I meant.
No,
I just don't quite see what you're worried about here.
Not at all. I'm robust. They're making findings of fact about what happened and making a judgment about whether they did or they didn't happen. Was it linked to Motawala? Was there, and so on. And then it comes to the question whether or not all those matters of fact, a Shamoon question, why did this happen? Haven't got a comparator. Why did this happen? Looking at all those findings of fact and asking itself, is there material there from which we can draw an inference, given things like the matters relied upon by the respondent, Mr. Motawala spring to mind, but the other 23 yesterday, bearing in mind those were not matters that, as a matter of fact, the tribunal found well-founded.
Yes,
And then,
right.
yes, so they find those matters of fact. They then say, given all that delay, and we haven't accepted any reasons for that, we're left with an unreasoned delay. We then ask ourselves, having regard to the failure to have a proper equal opportunities policy, having regard to the inadequacies in training, having regard to the statistical material, are we then able to treat the burden as having shifted?
Yeah, but you made all these points yesterday, and I have them very much on board. I just wasn't sure what in reply that you were emphasising this last point as if it was a response to something Mr. Hare had said.
The Laniardo point, the Mr. Laniardo point.
Well, no, you were making an elaborate point about how you could have a finding of fact which overlapped with the explanation, but all that's trite law. I still wasn't sure what you were worried about.
Well, I thought Mr. Hare was putting, in part, his case in that way, but because he made the point...
maybe he was. If so, I didn't pick it up.
Made the point that the tribunal were addressing the question when dealing with what was happening during the period of delay by asking themselves, what's the explanation at the first stage? But maybe I placed too much emphasis on that. And just dealing, my lord, with the how much value does the training issue, or indeed the equal opportunities policy issue, have? How much weight should be afforded that in the shifting process? I don't recall what your lordship said. Perhaps you were sitting as a first
it may not. Well, let's assume that there's no authority about it at all. Because I can't. It may not have been Natfi and De Silva. I honestly can't remember. Clearly, as a general proposition, if you have a workforce who are not given training in diversity issues or adequate training, including possibilities of unconscious bias, that in principle, at a very high level, makes it more likely or less unlikely, whichever way you like to put it, that they will discriminate. But it doesn't get you very far without something in the facts of the particular case to believe that happened. There used to be a rather mechanistic approach to the IGEN characteristics, which basically said, if you can tick a box and shows that someone, I think one of the IGEN points is availability of training, I believe. If you can show there wasn't training, well, that can be a basis on which it is proper to infer discrimination. And what I'm putting to you, with I think the support of authority, but if not, I'm putting it to you anyway, that by itself won't get you home. It's simply a common sense proposition that if there is material that might make you suspect discrimination, it is more plausible if the individuals in question had no training in discrimination issues. But it doesn't. It can't by itself have great weight, can it?
Well, in my submission, it does have great weight. I don't say that by itself it's sufficient to shift the burden. So I'm not saying that at all.
It's great weight.
I say great weight. Well, my lady, the question of equality and diversity training has been something that has been the subject of guidance, including from the Equality and Human Rights Commission and the predecessor commissions, for many, many years.
Because it's obviously very important.
It's very important.
That's at what I might call a general level for a workforce. On the facts of a particular case, I'm suggesting it doesn't always have great weight. Indeed, won't usually have great weight.
Well, what I have submitted is that it will not, by itself, I accept, absent some particular circumstance, by itself justify shifting the burden of proof without more. So a difference in race, a difference in treatment, and a mere failure to have diversity training, absent some special matter peculiar to the case, will not, I accept, be sufficient to shift. We're not in that territory here. We're here as treating that as one of the matters that the tribunal was entitled to rely upon in determining whether the burden had shifted.
But sorry, but on the delay issue, as you've said, they didn't do it by reference to a comparator. they did it by reference to a general complaint that the delay was unacceptable and calls for an explanation, and we don't find the explanations satisfactory. Therefore, the claimant wins. But I really find that very difficult in relation to delay.
I would have to mark that up a bit better. Mr. Jupp is helpfully handing me De Silva, but I can't listen to a question and read it at the same time. So,
well, frankly, it doesn't matter whether I said. I put the point of principle
you've put
to
the
you.
point, my lord, and I've addressed it. So, my lord, I beg your pardon. I've now distracted myself. Forgive me.
You said a difference in treatment and other factors such as lack of training and so on may be enough to shift the burden. But when we're talking about the delay complaint, as you've rightly said, they didn't say Mr. Karim's complaint was delayed when you put it alongside the complaint against Laniardo. Therefore, it's much more generalised. They say that it took an unacceptably long time. That calls for an explanation. The explanations given we don't find satisfactory. Let's put aside their detailed reasoning about that. Ergo, the balance has shifted, but why?
In my submission, that's not what they did. It was a much more sophisticated analysis. They looked at whether or not there had, as a matter of fact, been delay. And of course, that means something other than just it took a long time. Was there delay? Was it slower than it ought to have been? And they make findings of fact in relation to that by determining the matters that the respondent relied upon. The tribunal said this took a very long time. Why was that? The respondent said, well, it was for the following reasons. The tribunal said, those reasons do not explain or do not tell us why it took so long. They then go to the conclusions. We have delay. We have to ask ourselves why, bearing in mind at the moment we've no reasons for the delay. There's a vacuum there. And we have statistics, equality training, and the other matters relied upon. My lord, if I can pose the question in relation to this differently, how would a claimant demonstrate that delay, whether it was a year or 10 years for that matter, how would they demonstrate race discrimination if they were not able to analyse it in this shamoon way, if they were not a comparator? They must be able to run a case without a comparator and then draw inferences from matters around it. Those matters around it included that there were no reasons for the delay, and of course this was a case where there were other concerns about discrimination emerging from the GMC, in particular in relation to Mr. Laniardo, statistics, policies, and so on.
Why couldn't a case be run with comparators? And if you were able to take a sample of GMC cases of alleged misconduct and were able to show a pattern of cases against ethnic minority registrants taking a lot longer than cases against white registrants, that might be overwhelming. What?
Well, we'd have to undertake primary research because that research hasn't been undertaken.
Yeah.
So
That's sometimes the case. You can't.
Yes.
If the evidence isn't there, you can't say, well, how can we prove our case if there isn't any evidence? Well, the answer is you can't prove your case if there isn't any evidence.
May I just raise the question again, or raise the issue again I did yesterday, which of course there was a lot of cross-examination on this issue, as you might imagine. And one of the respondents' witnesses, Ms. Farrell, when asked by me, we don't have the notes of evidence, but trust Mr. Hare will jump up if I'm misrepresenting it. When asked about delay, could she provide any other examples of where delay where a case may have taken that period of time to conclude? And she struggled with it, but said, well, there are criminal cases like murder and manslaughter, and we're not in that territory. Now, the tribunal heard that evidence. We cross-examined on it, and with respect, that is one of the difficulties with a hearing like this, where matters are being put without the benefit of hearing all the evidence below. So I take your lordship's points and your ladyship's points, of course, in relation to reasons, and I accept, as I must and I should, because it's right for me to do so, that I set the threshold too high or too low, depending on how one looks at it. Yesterday, when I suggested that it might only be for the parties' benefit, of course I recognise it must be possible for a reviewing court to determine whether the tribunal had approached its task appropriately. But nevertheless, that is the limit of the function here. And I make no more submissions about that. I've made those. But safe to say that when one is exploring this, well, why did this happen? One must bear in mind that one is necessarily having to engage in the facts without the benefit of the 5,000 pages worth of documents and the extensive cross-examination.
Well,
so that's the...
We certainly have that point.
Yes. Just, if I may, in relation to comparators, I don't need to take you to it, but Hewage, tab 15, which is your lordships and your ladyship know is the Supreme Court case on burden of proof and comparators, at page 287 of the bundle, that's the bundle numbering. Would your lordships like to go to it? Yes.
Well, it's the same as we said. You can't say you don't need to read it, but I'll just tell you.
Sure.
I'll give you.
Of course.
This is Lord Hope saying more or less what he'd said 10 years earlier in slightly different language.
Yes. I mean, the reason I wasn't going to take you to it, because I was simply going to make that point, that really he makes clear it's a matter of fact and degree. It's a matter for the tribunal's judgment as to whether a person is a comparator, having regard to all the circumstances. So in that case, it was argued that the circumstances were so different between the two cases that it wasn't proper to treat them as comparators. And Lord Hope makes the point that at paragraph 22, the question whether the situations were comparable is, however, a question of fact and degree, good deal of evidence the other way. Of course, we don't have that evidence, but simply to make it clear that so far as the face of the decision is concerned, I invite your lordships and your ladyships to recall that, of course, the tribunal is making a judgment about the evidence it has before it in deciding whether...
The statutory test is no material difference.
Yes.
And that's what Lord Hope is discussing.
Precisely. And what's material is a matter of
There's
judgment.
obviously an element of judgment.
Absent perversity,
of course.
And then, please, I've got two matters. One I can take extremely briefly, but I know there are some behind me that are very keen for me to make the points, I will. But just if I can go to the more substantive points, and that's on the issue of statistics.
Yes.
Just to tell your lordships where we were with that to some extent. So if you look at the applicant's supplementary, the appellant's supplementary bundle, please.
Yes.
And if it's convenient, if you're able to, then paragraph 99 of the tribunal's decision as well, page 170 of the claimant's bundle, and paragraph 99 of the
we've got them.
So I'll just take you through this a little slowly. I hope not too slowly. But so if we look at, please.
Well, I mean, obviously you must do what you want, but the short answer to our question is D181 now appears at 175 in what you helpfully showed us.
Yes.
And that's where those figures came from, and nobody's suggesting that the figures are wrong.
Nobody suggests the figures are wrong, but I think your lordship, or perhaps your ladyship, I can't recall, also asked the question, well, was there any evidence about problems within the GMC itself as opposed to the referral issue? So there's evidence, and that was explored yesterday, I think, that there are a disproportionate number of referrals made to the GMC by employers.
Yes.
But the question
or patients.
Or patients.
Yep.
The question arises then, well, what can the GMC do about that? Is there anything that GMC we can deduce from the statistics that indicates that the GMC itself may have difficulties? So if we look, please, at page 176. At 176, top of the page, there are boxes, rather like comment boxes. Your lordships and your ladyships see that. And if you look at the middle box, for UK graduates, BME doctors were 50% more likely than white doctors to receive a sanction or a warning. And I ought to have told you what this document was. Forgive me, it's a GMC document. I beg your pardon, I should have said that first of all. So we see that at page 170.
Yes, this isn't a point that the tribunal makes.
Yes. Yes. And then at page 177, a document referred to in terms in our submissions below.
So was 176 referred to in your submissions below?
I don't know if it was referred to in the submissions, but all of them, there was extensive, I'll just tell you, some of them there were copies, so they may have more than one number, but I can tell you that the references start at S, supplementary bundle, agreed supplementary bundle 6.
Yes.
And I was just about to show you that a document...
Sorry, no, you do it in your own way.
Perhaps I can just deal with it like this. You can see at supplementary bundle, I don't need to take you to it, supplementary bundle page 6, the footnotes in relation to the statistical material relied upon by the claimant makes clear that this document was relied upon and references were made to it.
Hang on, sorry. See footnote 1.
See,
Footnote 1 refers to the Stephen Lawrence report.
no, I said footnote 9.
I think you should say footnote 6, but it doesn't matter.
Right, so if one looks at...
Yes, okay, I got that. Yep.
So if one looks, for example, starting at 3, we've got fail to refer, fair to refer, and so on. And then we've got over the page, state of medical practice, state of medical...
Yes, you know, I don't think there's any doubt that this document was referred to.
Yes.
Sorry, I was asked you a more specific question, which was whether the point that you had drawn to our attention on page 190 of the original bundle number, 176 in our bundle number, about BME doctors being 50% more likely than white doctors to receive a warning, was made to the tribunal.
At supplementary bundle 7, paragraph, just above paragraph 3, paragraph 2.6. We make the point, BME doctors are also more likely to...
No, that's very helpful.
And it's referring to this document, albeit that not that page, but it could be a summary chart, case maybe. It's this document, that point.
Okay, thank you.
And then if I can ask you to look at page 177 of the appellant's bundle, and we can be in no doubt that this was referred to below because it's that this particular reference 829 is given in the footnotes.
Yep.
So 177, we can see here a table 31 at the top of the page, licensed doctors complained about by ethnicity, by most serious outcomes of complaints. And then we can see about investigations, the middle box, the middle row, middle box, first row in the middle shaded box, BME full GMC investigation, overall, so if one goes to the end, one gets the overall percentage.
Well, that's overall for a 5-year period.
Yes,
That's what overall
yes.
means. Yep.
41.8%.
What does that mean?
41.8% of BME doctors are referred to for a full GMC investigation. In other words,
I'm not saying that's wrong, but that is obviously is that what it means? Is it?
yes, and that means it's past the triage. So it goes to the Rule 4, and then it's referred to a full investigation.
Mm-hmm.
And if we look at what happens to white doctors on that issue, 1, 2, 3, 4, 5 down, white full GMC investigation,
Yep.
30.3%.
But you can't really tell whether that simply echoes the fact that a smaller proportion of white doctors are referred by third parties. This isn't, I think, measuring, or is it? It's not clear. The proportion which, once received, proceed to a full investigation.
Well, that must be right, my lord, because...
What must be right? What I said or what you said?
What I say.
Yeah, okay.
Of course, this will have been the subject of extensive argument, but
I'm sorry to interrupt,
Not at all.
but doesn't this simply underline the point made by Mr. Hare that this is all very well, but the tribunal didn't deal with any of it?
they do deal with it, madam. They do. Forgive me. I've been in the tribunal, my
No,
lady.
but you've got paragraph 99, of course, and there's a reference to D181. I see that.
Yes.
But you said again that this was subject to extensive argument and examination in the tribunal, and we don't see any of that.
My lady, I can only say that in our submission, as I've said already, so I don't want to labour it
Just
too much.
presume they discarded all that detailed analysis.
The tribunal, in my submission, is obliged to make a finding of fact. It's not obliged to recite the evidence.
Yep. Well, this is where we were yesterday, but I mean, I think the problem about, I don't blame you because we asked to see where this came from, and Mr. Hare has made points about what the material that the figures that the tribunal referred to, why they don't really take us anywhere. So I'm not blaming you for coming back to us in reply, but actually, the more you show us that it's all quite sophisticated, you have to look at this, you have to look at that, that's very double-edged from your point of view, because the tribunal has got to do that.
I can only make the point again.
No, I know.
It's not going to get better
absolutely.
with repetition.
No. Okay, thank you.
I didn't actually give you all the references.
Yes, do.
Because you didn't ask. You took us, I think, read the figures given in paragraph 99.
No, by all means do. I mean, I just assumed they got those right really because they gave us. Yeah.
I don't think it seems to me there isn't a dispute about this now. That is that the figures in paragraph 99 are accurate. We produce the material at page 172 to 177 just to show your lordships and your ladyship the underlying material, because that was explored yesterday. And really, I think your lordships and your ladyship are most concerned with the question, why wasn't the material on the other side dealt with? So there's nothing more than I can say than I've already said to I hope assist you to the best I can on that question.
You made submissions as in supplementary bundle page 7. You've just showed us that the Plymouth report was pretty useless for reasons X, Y, and Z. But we don't know what the tribunal thought about that because they don't mention it.
It's our submission. The tribunal are bound to make findings, and they're not required to recite argument. And is as I've indicated, I think repetition won't improve it.
Yes, thank you. So, well, thank you. Yes, sorry. I would. Have you now had the chance to point out anything in particular on D181 or 175.
Only that, as I've indicated, if the figures are accepted in paragraph 99, as I understand they are, the question really is why wasn't the other side dealt with? Then it's not necessary for me to take you through them. It's just it was an issue raised by your lordship, and I've endeavoured to show. I've endeavoured to show.
Well, I'm just looking at it. It's fair to say, if you look at D181, it is in fact, though you have to look quite carefully, giving figures both about referrals and about what happens to them after referral.
This is page 177, my lord?
No, 175.
175.
Which is the table that the tribunal was looking at. So the shaded, the hatched box, let's just take, which is difficult because they're split up by age. But in principle, you could do an exercise. I mean, just looking at it visually, looking at it for the over 50-year-olds, to 28% of BME registrants, or GPs, this one is, get referred, of whom rather under half, just looking at it visually, because you aren't given any figures, lead to an investigation. Whereas for the white equivalents, it's 17% get referred, and a good deal less than half lead to an investigation. Yeah, I really can't put a figure on it.
And specialists, of course, the middle.
Well, all right, but I'm just illustrating the exercise you then have to do, yeah. And that's, I think, reflected where in the box on the right. Well, no, it isn't. That's not looking at race. That's looking at where you were educated, where you were qualified. But it does make the same distinction between it's very it needs the exact nature of the distinction being made in the box between being investigated and leading to a sanction need to be much more thoroughly understood than we can do.
There is a short commentary on the page before. I'm not sure it takes matters much further, but just so you have it. The first paragraph deals with the more likely to be complained about, and then, by contrast, a high proportion of complaints about what white doctors are closed before investigation, and then much of the difference between BME and white graduates is associated with the fact that male BME UK graduates were more likely to be complained about and to have their complaints fully investigated. So it's merely picking up the points that then follow.
And at the sanction stage, the group who are treated most harshly are white EEA graduates.
Sanctions.
Yeah. Page 176 of the run. Very complex statistics.
Yes, because on 175, looking at your middle graph, not the one my lord was dealing with, it looks like the variation is far narrower when we're dealing with specialists than when we're dealing with GPs. much closer. And of course, we're dealing with a specialist here, which perhaps feeds into, for my own part only, my anxiety about paragraph 99.
I think that the truth is, I don't in any way want to shut down anything you feel you ought to say. As one hand, I'm grateful to be shown these, and it does put flesh on the bones of what exactly the tribunal had in front of them. But the overall submissions that you and Mr. Hare have made are really stand. We certainly shouldn't be deciding this case by attempting to form our own view about what these statistics show, and I'm certainly not going to try and do that. Yes.
And I, of course, don't invite you to. I think that may be it, subject to one matter. I'm asked to just alert the tribunal, the court to. May I just take a moment to check my notes?
Yes, of course.
Oh, yes, paragraphs. I should deal with paragraph 75 and paragraph 73 and paragraph 95. So what's said to be a conflict. Take you back to that. And it's our submission that the tribunal are dealing with different points. So when they're dealing, forgive me, at paragraph 73 at page 123, about Mr. Rao, they're dealing with a much larger group of complaints about the fitness to practice decision, that is sending it through for determination by the MPT. So they're dealing with a larger group of complaints in one go and dealing with them all together. And when they come to 95, their focus is on the particular complaint in relation to Mr. Rao so far as it's comparable to Mr. Laniado. So it's our submission that the focus is different there. And you'll see, of course, at paragraph 73, the tribunal doesn't direct itself to a comparison with Mr. Laniado. It's dealing with the overall, and then comes back to the comparison with Mr. Laniado when it comes to 95. And then my Lord Justice Bean, perhaps we've explored this to some extent this morning, but my Lord Justice Bean put to me yesterday, what would an employer, or for that matter a qualifications body, have to show to disprove a complaint of discrimination in these circumstances? May I put the alternative case, rhetorically perhaps, what would a complainant have to show beyond that which the claimant showed in this case, in particular in relation to the complaints with a comparator, beyond an equal opportunities policy, complacency, benevolence in the case of Mr. Laniado by taking account of the dysfunction, a tenacious investigation in relation to Spire, and an unnecessary link with Mr. Watawala. So it becomes increasingly more difficult. And may I say, it was a point I alluded to yesterday, but I perhaps should say in more clear terms today, of course the burden of proof provisions were enacted with the hope that it might make it easier for claimants to succeed in complaints of discrimination, where success rates have been historically very low.
I think on dangerous ground there, they were enacted to reflect the requirements of EU law.
Yes.
it's very much an open question whether the common law hadn't already got there by cases like King and Great Britain China Centre. I think it's dangerous to think that the burden of proof provisions were intended to change the position. They were simply intended to reflect what EU law required. I think many practitioners thought, maybe not all, that they didn't change much compared with what the law had already reached.
Well, of course, Anya and those cases, King and so on, were concerned with a shift in the evidential burden. There wasn't a legal burden imposed upon a respondent in those circumstances, whereas now there is a legal burden imposed. And as to the giving effect to the directive, whilst it's true that the changes were made to give effect to the directives, the provisions in the directives were dealing with effectiveness, and so addressing the burden of proof in that context.
Yeah. Okay. Anyway, you say your basic point is if the burden of proof doesn't help in a case like this, this is just the sort of case in which it was intended to help.
Precisely. And then one last point, as I indicated, just really, it's another way of making a point of I've already made, but the those who sit behind me would like to make this particular point. It was said in submissions yesterday by Mr. Hare that one of the differences between Mr. Laniardo and the claimant was that in the case of the claimant, there were those that did not corroborate his account of the meeting with Mr. Rao, the canteen meeting, whereas there weren't any witnesses that were in opposition, for a better expression, to Mr. Laniardo. That's not the case. I don't need to take you to it, but at page 91 of the Respondent's bundle, the Hollywood report in relation to Mr. Laniardo makes clear that Mr. Kelsey supported Mr. Rao's account. So it's a small point, but I suppose it goes to illustrate again the difficulties with, to some extent, what we might be tempted to do, which is retry the case in an appeal. May I just take one moment?
Of course.
Thank you.
Mr. Hare, this is not by way of encouragement, but we have, Ms. Monaghan has produced a document which you haven't had the opportunity to comment on. Do you wish to comment on it?
Can I just do so very, very briefly, my lord? Just to say this. The important point about the statistics on the progress of investigations of the GMC is that not only was the decision to triage Mr. Karim's case not one of the complaints that were raised, it's not addressed by the tribunal. That's the question about whether or not it gets through the triage stage. And secondly, and I showed it to the tribunal, it's in two different places. The Employment Tribunal at ET 73 and 95 accepted that it was proper for the GMC to progress.
Sorry, you're speaking so softly.
I'm sorry. The Employment Tribunal accepted at 73 that it was proper for the GMC to have progressed the allegations which went forward to the MPT and didn't find less favourable treatment in relation to...
Well, no, I wasn't really asking you to make news.
No, it's not a new point.
Again. I was just whether there was any points on the documents.
Yes, it is on the document, because the question, my learned friend relies on the document to say it also shows that black and minority ethnic doctors are more likely to be investigated by the GMC, not just reported to the GMC.
Yeah.
And so it is relevant.
Okay.
The two decisions there are to open the investigation and then to pursue the investigation. In relation to both of those, there's no finding of discrimination or less favourable treatment by the GMC. The first wasn't even challenged. Thank you.
Right. Thank you both and those in the teams behind you for your all the work that's gone into this. solicitors for their submissions. We will be considering our decision. Copies of our judgments will in due course be provided in draft to counsel for the very limited purposes that appear in the general Counsel General for Wales case. That may mean that they will have to be circulated to some extent within the clients, but they are only to be circulated for the purposes identified in that case, and any circulation for any other purpose or to any other kind of person may be a contempt of court. Thank you very much.
All right. I just thought I'd show you the seat because it's not